Jurors viewing a chilling videotape confession in the trial of the accused Charleston shooter Dylann Roof. Roof faces 33 federal charges of murder and hate crimes for the shooting deaths of 9 black parishioners at a historic church. 21-year-old telling investigators about the rampage after he was arrested the next day.
Well, I killed him. Well, I guess. I mean, I don't really know.
Well,
I don't know how many people were even.
So did you shoot him?
Yes.
What kind of gun did you use?
A Glock 45.
Okay. Was that your gun or?
Yes, I bought it from the gun store.
Joining me now is Robert Schalk, defense attorney, former prosecutor, and David Bruno, criminal defense attorney, trial attorney, and former prosecutor. Good to see you both. So, Robert, first of all, he's laughing during the confession. And second of all, when asked about his motive, he lays it out, racial hatred. Question, do you consider yourself to be a white supremacist, Roof? I do consider myself to be a white supremacist. We're superior. He's not only admitting to the crime, but he's admitting to the death penalty part of the crime, a hate crime.
Yeah, the videos, his lawyers have no outs here. There's really nothing that they're going to be able to elicit through testimony of any witness that's going to refute what he said. I killed these people, and I did it because of racial animus, racial hatred, and right then and there, if the jury follows the law, he should be convicted, and he more likely than not will receive the death penalty.
You know, David, he wrote this 2,000-page statement, a manifesto. It was on the internet, in which he says he's got to do something about, forgive me, but these are his words, you know, black people killing white people and raping white women. Here's a soundbite. Let's play one more soundbite for you.
So I could have walked out, you know, and that's what I was just thinking, you know. But then I just, you know, like I just, like, I don't know, just like, no, you want to say spur of the moment, but you know, I just finally decided I had to do it. And that's pretty much it.
I mean, the prosecutors really don't have to do anything. He lays out a hate crime murder.
Yeah, well, the fact of the matter is there's going to be 2 phases to this trial. First is the guilt phase. And as we hear, he admits it. I mean, there's no dispute. In fact, the lawyer in the opening statement said they weren't going to call any witnesses and they weren't going to provide any evidence. So essentially, this is a death penalty case, and the most important phase is the death case.
Right.
And while that statement proves that he did it, it's also going to dehumanize him, because defense attorneys want to humanize. They want to humanize the individual, so when the jury is asked, are you going to kill him? They say no.
And then he says, I'm guilty. We all know I'm guilty, to the feds in his confession. I mean, you can't make it any more abundantly clear than that, can you?
It's extremely difficult, the job of the defense attorney in cases like this, because everyone at home is sitting there saying, this guy is so guilty. Why doesn't he just plead guilty? Now, they offered to plead guilty with life on the back end.
And the feds said, no way.
Absolutely. Why would they, though? Why would they? They did the right thing. The feds shouldn't have put this. I mean, obviously, no one wants to see the families go through the trial, but you don't give the farm away in cases that call for the death penalty, and they believe this case calls for it.
David, you think this is very much, and I agree with you, like the Boston bombing case. Explain.
Yeah, sure. Well, they're both federal cases, and that's the start, because the procedure in federal court and state court are different depending on the states. In fact, here in South Carolina, they have a state court case that's going on as well.
That'll be next.
First in history. 2 death penalty cases, 1 in federal court and 1 in state court.
Yeah, but the similarity is that it was a slam dunk on the guilt phase in the Boston bomber case, and he ended up with the death penalty in the second part.
They did not challenge the guilt phase either in Boston bombing. And like I said, while it's not being challenged, they are thinking about the penalty phase throughout that first phase, the guilt phase.
You know, so you get to the penalty phase, Robert, and you have to weigh aggravating factors versus mitigating factors. Here are the aggravating factors: multiple killings, substantial planning and premeditation, and heinous, atrocious, and cruel. I mean, that's got to outweigh any mitigating factor, and I'm trying to figure out what mitigating factor there'd be.
I was doing the same thing in preparing for this segment, thinking what mitigating factor, and the only thing I can think of is his age, and that's not going to do it. They only think he's a young kid.
What about this? Sort of an intellectual incapacity. I mean, you hear him in this confession, and he's very slow-witted and unsure of himself. It seems like there's something mentally wrong with him. And yes, there was a competency hearing. He was determined to be competent.
Yeah, could be. And what's interesting about this case as well is Roof plans to represent himself at the penalty phase.
He may change his mind.
He may change his mind, but he brought the attorneys back for the guilt phase only. Said to the judge, I'm going to represent myself at the sentencing. So what is he going to provide? What is he going to say?
Oh, he's only going to make it worse.
Oh,
Probably.
He's going to get up there and make it 10 times worse. And
Right.
I agree with Greg with the fact that even if he was examined, competency versus whether he has a mental illness are two different things.
They are.
And whether or not he has cooperated with his lawyers enough to spell it out, I doubt it
All right.
based upon his actions to date.
Robert and David, good to see you both. Thanks.
Thank you.
Thanks, Greg.
All right. Art.